Okay, council, just give me 1 second. I've got a party here in the waiting room. I'm not sure what case they're on, so I'm gonna bring them in here real quick and see. All right, Mr. Brock, if you could unmute yourself, please. There we go. Can you tell me what case you're signing in for?
Yeah, I'm signing in for the Cas Green matter.
Okay, great. All right. So I think we have everybody connected. We'll go on the record. This is Green versus Allison, case number 2311318. And it looks like we have everybody present. If I could have council put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Alexander Waldman on behalf of the plaintiff.
Likewise, on behalf of defendant Allison.
Good afternoon, Your Honor. Cody Brock here, appearing on behalf of Nationwide.
All right, thank you. This is set for a status conference today. I believe that was adjourned out by stipulation. But Mr. Waldman, on behalf of plaintiff, can you kind of tell me where things are at and then what you would like to request going forward in terms of scheduling?
Sure, Your Honor. I think most of the discovery has been done. It was brought to my attention today that my client had failed to appear at an October 13th IME. So I wasn't aware of that. I do need to talk to my client about what happened there. I don't have any issue with her appearing for an IME, but obviously I believe Ms. Wysanen wants the IME before we can have a competent discussion about resolution on this case. Presently, we have mediation scheduled for December 4th. I personally think the case is what it is, but I'm not going to deny their ability to take an IME if that's what it's going to take to settle the case. It was just brought to my attention today. Had I known back in October, we would have gotten it rescheduled, but I had no idea that she had missed an IME appointment. So.
Okay, and you said there's mediation set for December?
December 4th is, I believe, with Judge Ryan. Is that who we chose, guys?
Yeah.
And I'm still dealing with an Optum lien. I don't know if the court's been dealing with a lot of personal injury cases, but Optum has just been an absolute disaster to be dealing with on multiple cases that I've had. So I've been chasing them, working with Cody on trying to get the proper charges on the lien so we can resolve the PIP claim. It's a very small PIP claim. I don't think for his purposes an IME is relevant. I think we want to settle the case. We just need to know what the true value of the case is for purposes of settlement.
Okay. All right. Ms. Wysanen, anything you wanted to add?
No, I think Mr. Waldman covered it. We've taken a lot of depths in this case. We've really worked diligently. The only thing left is I need to get a new IME date. Before I do that, I'm going to touch base with Mr. Waldman to see if the client has maybe a work schedule that we have to work around or something. It could be that she just slipped her mind, but I have no doubts that we'll be able to work together on that.
Okay, thank you. Mr. Brock?
Yeah, like Brother Counsel said earlier, that we've been working together to try to get this one resolved. Anything he needs from us, we're happy to provide to him. I have the EORs that we paid, and now we just got the updated Optum link, so we're working together and hopefully resolve this soon.
I think maybe for purposes of scheduling then, the court will set this for another status conference by Zoom right after the first of the year. Parties will have mediation by that point, and then I think we can see where we're at. Does anybody have any objection to that?
Your Honor, the only thing I would point out is it's November 9th. These doctors, for defense doctors, oftentimes don't. Oh, I'm so sorry. Defense doctors often don't. I don't know what availability the doctor is going to have. I just don't want to jam anybody up. I have no problem doing a status conference, but I don't think the December 4th mediation date is going to be helpful if my client can't get to the doctor before then. And while I know it's a little less than 30 days out, the reality is it's probably not going to come to fruition before mediation. So I'm anticipating that that's probably going to have to get moved again. And I don't want to waste the court's time in January where we say, well, she just went to the IME. We've now scheduled mediation for February or whatever. So I'd only point that out to say I don't want to waste the court's time. I think we've only done one adjournment on this case. It is a 23 filing. I know the Supreme Court says get them done in 2 years. I do think we're on track for that anyways, but I just wanted to point out that fact so that the court's not frustrated with us coming back saying, well, we still need to mediate this case and we'll see what happens.
Yeah, that's a fair point. Go ahead, Ms. Waisana.
I will try as soon as I think Mr. Wellman will talk to his client today. We should know soon, because as soon as I know if she has certain days she can make for that IME, we'll reach out to that doctor and try to get that rescheduled. I do think, based on this doctor, because the doctor is closer to where Miss Green lives, that I think they have more availability than some of the doctors that are closer to Detroit, simply just because there's not as many people up north for these IBs. So I think we could get it scheduled before the December 4th. But the trick is, do we get the report back in time? So there is some variables, but even if that's true, I think we could make a good faith attempt to keep the facilitation date, even without the IME, but we would certainly need the IME for trial. So if Mr. Waldman will work with me on doing that, I will try to keep that facilitation date if we can.
All right, well, I'll set the status conference for February then. And, you know, if for some reason you're not able to get the mediation done in December and it's got to be pushed out, even if it's not ready by that February date, if council puts together a stipulation order, you know, if you have a mediation date at the beginning of February and it's going to coincide with that status conference, then if council submits a stipulation order, just move it out 30 days or whatever, it needs to be moved out so that the mediation is done before we meet again. I certainly don't have a problem with that. And then if everything goes as planned, then we have a date in February already set. So let's go forward that way. Mr. Waldman, anything else I can address for your side today?
No, Your Honor. Thank you for taking the time today.
Thank you, Ms. Lysanen. Anything further from your side?
All set, Your Honor. Thank you.
Mr. Brock?
Nothing further, Your Honor. Thank you.
Okay, thank you. All parties on this file are free to disconnect at this time.
Thank you.
All right, Mr. Bloomberg, are you able to hear me okay? Sorry, everybody's muted.
Okay.
There we go. Okay, good. I think we got everybody connected. We'll go on the record in Sensy versus Balky, case number 2311454. We have Mr. Thompson here with his client, Ms. Sensy, by Zoom. Mr. Bloomberg also by Zoom. And is your client with you there, Mr. Bloomberg?
Yes, he is, Judge.
Okay. This is set for a pretrial scheduling conference today. I believe this is our first meeting on this file. Mr. Thompson, on behalf of plaintiff, can you tell me where things are at and what you'd like to request going forward for scheduling?
Yeah, I think the only issue in this case is going to end up, there is some shared property. There is more. The only issue in our buyout of that shared that the party divorce case, there's no claim support on side, there's no child related issues. So I would think this could be negotiated or tried relatively.
All right, you were breaking up quite a bit there. I don't know, Mr. Bummer, if you were able to hear all of that. Do you want Mr. Thompson to repeat any of that, or were you able to get the gist of what he was saying?
I got every other word, so I guess I think I understand what he was saying. We have a different view of that. This is a short 5-year marriage. Each party had their own separate real estate before the marriage. So I wasn't quite clear of what Mr. Thompson was saying, that his client would be entitled to some percentage of equity in my client's separate property. Is that what he was saying?
No, Mr. Blumberg, after the marriage, the parties purchased additional real estate, contiguous, adjacent, premarital real estate in his home. And so that's what need to be divided, or, one party purchasing the other out. So I believe that's the issue.
I would agree with that. I'm sorry. Again, I misunderstood what he had said.
All right, do you guys want to have some time to negotiate this on your own? Do you want me to refer it right away to mediation? Mr. Thompson, what are your thoughts on that?
I think this would be one, I think with some time, the attorneys could take a good crack at negotiating. I think we could probably come back with short, good chance if we got on the January or February motion hearing schedule.
Okay, Mr. Blumberg?
Again, I only heard like every other word. So, but I think, I'm fairly comfortable that we could probably resolve this ourselves, Judge.
Okay, what I'll put in the scheduling order then is I'm just going to have discovery to remain open for at least the next 60 days. The parties to attempt to resolve it on their own. I'll set it for another status conference in early February. If we have everything set, we can use that date to take proofs. If not, then I think parties at that point will know whether or not they're going to be resolving on their own, or whether we need to look at ADR. Mr. Thompson, do you have any objection to that as a scheduling order going forward?
No.
Mr. Blumberg?
No, that's fine, Judge. Thank you.
Okay, Mr. Thompson, anything else I can address for your side?
No.
Mr. Blumberg?
I think we're all set, Judge. Thank you.
Okay, thank you. All parties in this case are free to disconnect. We'll send out the date for the next hearing to all parties in the mail.
Yeah, more probation orders than I do orders for you to sign.
Okay, council, if I could have you each unmute, please.
Thank
All
you.
right, thank you. Okay, we're on the record now in Hatfield versus City of Grayling. This is case number 2311440. If I could just have both council put your appearances on the record, please.
Amanda Danielewski for the plaintiff.
Good afternoon, Your Honor. Brad Werda for the defendant.
Okay, we're on the record here today for purposes of a scheduling conference, pretrial scheduling conference. I believe this is the party's first appearance in court here for since the filing of the complaint. One issue I want to raise before we get into setting dates, Ms. Danielewski and Mr. Weirda, my prior employment was with POAM. I was assistant general counsel for them for about 10 years. I left there to take the bench here in 2013. So it's been, 10 years since I've worked there, but I still have, some personal relationships with counsel there, as well as some of the business agents and board members. I know that POAM is at least part of this from what I read in the complaint. So number one, I wanted to disclose that so that you're both relationships. But also, POAM isn't a party. So it was hard for me to determine whether that would be a reason that I needed to look at to disqualify. So I guess Ms. Danielewski, what involvement do you anticipate POAM or any of their staff having in this? And I'm just trying to get a sense of how involved POAM would be in any decisions that the court would have to make.
I think minimal prospectively, because all of the work as it would relate to the current dispute with the city, I think has already been done. But I didn't have an opportunity to put a lot of thought to that. I feel like this case should be primarily one of damages based on the legal issues that we've teed up. So I'm thinking the involvement would be minimal, but I'd like to put some more thought to it, I guess. And I have to talk to my client, obviously.
Sure. Okay. Mr. Werda, any thoughts on that?
Yeah, I guess just briefly as to what Ms. Danielewski said, we would disagree that this case is just about damages. We don't think that a decision from the Court of Appeals in a case that we were not actively participating in is binding on us at all. On the issue of a conflict, we gave some thought to whether we should third party them in as a defendant in this case and decided not to. I didn't think that there were claims that were directly relevant. So I don't think that we would have any objection, to Your Honor's participation in the case.
All right. Why don't we do this? Ms. Danielewski, just for purposes of setting dates today, do you have any objection to me entering a scheduling order at this time?
No, thank you.
All right, Mr. Weirda, any
No objection.
So let's do this then. Let's discuss some dates. Let's get some dates going here. And then Ms. Danielewski, that'll give you an opportunity to speak with your client. I may end up, just from what I'm hearing here today, just disqualifying, just to avoid any appearance of impropriety. But certainly Ms. Danielewski, you would be well within, I think, your rights to file a motion too if the court ends up not disqualifying. And maybe we can, set a time limit on that today just so that we don't delay the case resolving that issue. So let's say, if within the next, let's say 30 days, if I don't issue a disqualification order, Ms. Danielewski, is that enough time for you to talk to your client and make a determination as to whether or not you'd want to file a motion, or do you want to have more time than that?
Could I get, well, my thought would be maybe I could have 30 days from when Your Honor makes a decision on whether to do it.
Okay, yep, I think that's fair. Any objection to that, Mr. Werda?
No, Your Honor.
Okay. In terms of discovery and just standard scheduling, Ms. Danielewski, any particular amount of time that you wanted to request for discovery in this case?
I think 180 would be just standard, so I think that would be appropriate.
Okay, Mr. Warda, any objection to that?
No, I agree with that. I do wonder, and I haven't approached this with Ms. Danielski either, but because there's an issue, on whether an earlier decision is the law of the case that, is included in the complaint, this may be a case where it would make some sense prior to doing discovery to hear a motion on that issue. I don't think there's any factual dispute on it. So I guess it crossed my mind that this might be a case where it was appropriate to address that issue through motions, dispositive motions early, and then kind of, commit to discovery after that, if it's necessary.
Yeah, so I think that's a good point. I'm not gonna set a cutoff for that kind of a motion necessarily in the order. I think that's something, council, to the extent that you guys talk about it and aren't able to reach an agreement on that issue, a motion on that could be filed at any time, and I would leave that to the discretion of council as to the timing of that, so. But I think that's a fair point, and that might be a good issue to get resolved before the parties do a lot of discovery. That would make sense. So we'll set a 180-day period for discovery. And then in terms of mediation, do you want to wait until after discovery is concluded to participate in mediation? Ms. Danielski, your thoughts on that?
Yeah, and if we could somehow leave some flexibility within that, there has been some interest expressed by the poem because we have a Mertz case that's going back up to the Court of Appeals now on the issue of damages. And to the extent the parties agree that we all want to globally facilitate, if we wanted to do it earlier, I'd need some flexibility in there. That would be great.
Okay, Mr. Werda, any objection to that?
No, I would agree to, maybe a discovery deadline or a mediation deadline around the end of discovery. But if we want to do it earlier, obviously I think the parties can do that if it makes sense.
How about if we set an outer limit of 30 days after the close of discovery for mediation?
Yes.
That sounds
Great.
So I'm going to write in the order, mediation is agreed by the parties, but no later than 30 days after the close of discovery.
Yes.
Yes.
Oh. Right, and then I think what I'll do then is I'll set this for a status conference at about that same time, about 30 days after the close of discovery. And then we can kind of see where we're at that point. I'm not going to set a dispositive motion cutoff at this point. I'd like to see where things go here at the beginning of the case, and then we can address that. And I'm assuming the parties would want to have a cutoff for that beyond the close of discovery anyway. Any objection to that, Ms. Danielski?
No, Your Honor.
Mr. Werda?
No, Your Honor.
Ms. Danielski, any other dates that I can address for your side today?
No, I think that should be perfect.
Okay, Mr. Werda?
No, thank you, Your Honor.
Okay, I'll put what we've discussed today into a scheduling order, send that out to the parties, and we'll go from there. Thank you. You're both free to disconnect at this time.
Thank you.
Thanks.
very historic,
Right.
and music everywhere. It's cool. You should go to Lafitte's Black Shop. Yeah, like the blacksmith shop. It's the oldest, one of the oldest places in the French Quarter. Pirate hangout.
Okay, we've got somebody on the phone, 0698 are the last four digits. Can you tell me your name, please?
Pauline
Yeah,
Scott.
Mildred Scott.
So the person on the phone, not the other person. Who's on the phone, please?
Mildred Scott, SCOTT.
Great, thank you. And then on Zoom, ma'am, you're Pauline?
Yes.
Okay, very good, thank you. All right, so we've got everybody present. We're on the record in Scott versus Scott. This is case number 2311426. And I have this set for entry of a judgment of divorce today. Pauline, is that how you wanted to go forward?
Yes.
And Mildred, are you ready to go forward with that today as well?
Yeah,
Okay. Pauline, I'm going to ask you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, yes.
Thank you. You can lower your hand. Pauline, I've got some questions for you. These are the questions that I'm required to ask to establish the grounds for divorce under Michigan law, okay?
Okay.
First of all, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Crawford County for at least 10 days?
Yes.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the judgment of divorce, you will not receive any alimony or spousal support. You understand that you would be waiving that forever and you would not be able to come back later and ask the court for that.
Yes.
Under the judgment of divorce, it indicates that you're going to keep whatever personal property you have in your own possession and that you're going to be responsible for whatever debts are in your own name. Is that correct?
Yes.
And it indicates that you don't own any real estate or real property with Mildred Scott. Is that correct?
Yes.
All right. And then you're asking to have your last name changed to Gray, Gray. Is that correct?
Yes.
Okay. All right. Mildred, are you able to hear me?
yeah,
Can you raise your right hand and let me know once it's raised?
yeah, good.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah,
Thank you. You can lower your hand. Mildred, do you understand that you also would not be receiving any spousal support or alimony as part of this divorce? You understand that you also would be waiving that forever and that you would not be able to come back later and ask the court for that?
yeah, I do.
All right. And did you hear all the questions that I asked Pauline?
Yes, I heard him.
Did you hear all of her answers?
Yes, I heard him.
Do you have any reason to believe that any of the answers she gave were not true?
No, I don't believe so.
All right. The court finds that based on the testimony of both parties in this case, that the statutory grounds for divorce have been met. The court will grant the divorce. I've signed that judgment. That would be available here at the courthouse in Grayling. Either of you needed a copy of that judgment for your records. Pauline, did you have any questions at all?
No, I don't.
Mildred, did you have any questions?
Oh, I do not.
Thank you. That's all for today, and both parties are free to disconnect at this time.
All right.
Are you gonna continue to waive their filing fee?
Yes. All right, if I could have you both unmute, please. Ma'am, is your name Christina Marthew?
Yes.
All right. And all right. On the Samsung device, sir, are you Pete Marthew?
Yes, sir.
All right, thank you. We're on the record today in Marthew versus Marthew. This is case number 2311443. The record should reflect both parties are present by Zoom video today. I have this set for entry of a judgment of divorce. Ms. Marthew, is that how you wanted to go forward today?
Yes.
And Mr. Marthew, is that how you want to proceed as well?
Yes.
All right. I'm going to place you both under oath. I've got some questions that I need to ask each of you. These are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. So if you both would raise your right hands, please. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hands. Ms. Marthew, because you are the filing party in this case, most of my questions are going to be for you. Ms. Marthew, you filed the complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes. Yes.
Had you been a resident of Crawford County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the judgment of divorce, you would not receive any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
Also, under the judgment of divorce, you and Mr. Marthew will keep whatever personal property is in your possession, and you would each be responsible for paying whatever debts are in your own names. Is that correct?
Yes.
And it indicates that you don't own any real estate or real property. Is that correct?
No, no.
Okay. Mr. Marthew, have you heard all the questions that I asked Ms. Marthew?
Yes.
Have you heard all of her answers?
Yes.
Do you have any reason to believe that any of the answers she gave were not true?
No.
Under this judgment of divorce, you also would not be receiving any alimony or spousal support. You understand that you also would be waiving that forever, and you would not be able to come back later and ask the court for that.
Yes, I understand.
Thank you. The court finds, based on the testimony of both parties, that the statutory grounds for divorce have been met. The court will grant the divorce, and I sign that judgment. That'll be available here at the courthouse for either of you if you wish to have a copy of that for your records. Ms. Marthew, do you have any questions at all?
No, I don't.
Mr. Marthew, did you have any questions?
No, I do not.
Okay, thank you. That's all for today, and both parties are free to disconnect at this time.
Thank you.
Would you like me to go
Yeah. No, they don't.
Whatever.
If they need anything signed.
Yes.
Clock is ticking.
Yes. Before you leave and I forget they're down there.
Thank you.
Yep.
Probably not the record. No, I got one more.
Who's left to go?
Ladak.
Oh, okay.
Bradsher. Okay, council, if I could have you on mute, please. All right, thank you. We're on the record now in Ladak versus Bradsher. This is case number 2311388. If I could have both counsel put your appearances on, starting with plaintiff, please.
Daniel Randazzo on behalf of Logan Ladak.
Good afternoon, Your Honor. Julie Firschman appearing on behalf of the defendant, Alexander Bradsher.
All right, thank you. We're on the record here today for purposes of a motion hearing. It looks like the defendant issued a subpoena for some school records of the plaintiff. Plaintiff is objecting to that subpoena. I did have a chance to read the motion and the response, as well as the plaintiff's reply, as well as to review the complaint and the file generally. Mr. Randazzo, is there anything you wanted to state in terms of oral argument in support of your motion today?
The only other thing, Judge, that I would add is that I never received a copy of the subpoena, which is required pursuant to court rule. I found out because the school district attorney called me and then sent me a copy of the email of the subpoena. And you know, as I said in my motion and in my reply, there's absolutely no reason for these records. It's not related to liability. It's not related to damages in any way, shape, or form, unless I'm completely ignorant. There's no justification for it. It's onerous, and I think it's intended simply to find something that they can argue that my client, you know, has a 1.0 grade point average. So, you know, getting burnt was his fault, not the defendant's. I just don't see any reason for it.
Thank you. Ms. Firschman?
Your Honor, I appreciate that you've read the filings. First, with respect to plaintiff's counsel not receiving the subpoena, if that is truly the case, I would absolutely apologize, because as Mr. Randazzo knows, he would send me a copy of a subpoena, and I always send opposing counsel, as I'm required to, copies of every subpoena that goes out. So this is news to me. I can look into it. I was absolutely unaware of this, and this is not how I practice. So the first point I would make is I sincerely apologize, and that was not anything that I either directed or, as you can tell, was aware of. The only other thing I would call attention to is highlighting Michigan court rules regarding discovery, highlighting the fact that this, Your Honor, you have options in response to these motions. One, to permit the subpoena to be complied with, allowing plaintiff's counsel to revisit the issue later, file a motion in limine if it is warranted. The reasons why the information is needed, I won't delve into. We know it's not a strict liability case. I believe the information is important for liability evaluation and damages, not to be hoodwinked or surprised at trial. Your Honor, you can also order an in-camera inspection to the extent you want to see what's in this information. Your Honor, you can also order that the parties agree upon a stipulated protective order that would control the flow of this information, restricting where the information goes to, keeping it only within people, in this case, who need to know or review the information, such as my experts who may want to take a look at it. These are options, Your Honor, available to you, but I would respectfully ask that the motion be denied.
Thank you. Mr. Randazzo, it's your motion. I'll give you an opportunity to respond.
Just as with respect to the not receiving the subpoena, I've had cases with Julie in the past. I know she's always complied with the court rules, and so I don't know whether it was an oversight or what. But again, there's nothing that was articulated in the response that is related in any way to liability or damages. I mean, this is a case where my client was burnt by the defendant throwing a gas can. What his school record has to do with either one of those is beyond me. So I would ask the court to quash the subpoena. I mean, we're looking at grades 1 through 12. What possible information is going to help them with liability as it relates to those records, or damages for that matter? I just don't see it. So I'd ask the court to quash the subpoena.
Just a point of order, though. It's my understanding the subpoena was directed to the high school. I do not believe that my paralegal asked for elementary school records
You
in
asked
this
for
case.
excuse me, I'm sorry. You asked for his entire academic record from that school district. So it goes all the way back. And that was one of the reasons I filed the motion to quash. You asked for the entire academic record from that school district.
Well, I stand by what's in the subpoena. Your Honor, I leave it to you. I believe that it's still discoverable. There's case law cited in my brief that even if certain discovery would ultimately be inadmissible in the legal proceeding itself, it is still discoverable. And it's even in the court rule of 2.302B1 that information within the scope of discovery need not be admissible in evidence to be discoverable. So it's our position that it's discoverable, Your Honor.
Okay, thank you. Again, I did thoroughly review the motion and responses as well as the file prior to the hearing today. And counsel's arguments is largely consistent with those in the written submissions. Both counsel cited to the rules governing discovery. I think both counsel properly cited to those rules, and the court is relying on those in terms of its ruling here today. I agree with defendant that the court does have a lot of options in terms of how it can address objections to discovery. And in my view, although discovery is expansive under the court rules and case law, it's not without limits. And two of those limits are privileges and relevant evidence. So it has to be relevant or information that's relevant. And it doesn't necessarily, as Ms. Firshman indicated, need to be in and of itself admissible as long as it's reasonably calculated to lead to admissible evidence. Looking at the claims in this case and the defenses, the court cannot find at this point that anything in the plaintiff's school record, whether it's elementary school or high school, would be relevant to a determination of either liability or damages in this case. I just don't see, I have to agree with Mr. Randazzo, I just don't see in any way how anything that might be within those school records would be relevant to a claim that the defendant was negligent during this incident at the bonfire that resulted in the injuries, or relevant to what, if any, injuries Mr. Ladak may have or be able to prove. So at this point, I don't see that there is sufficient relevance to allow it to be discoverable. So the court is going to grant the plaintiff's motion to quash the subpoena. I will note that the court is doing that without prejudice. So in other words, if further discovery uncovers some basis for relevance, Ms. Firshman, I think you'd be within your rights if you're able to articulate a relevant purpose, then I think that would be a different story. But as it stands now with the information before the court, I don't find that there would be any relevance to that, even under a liberal interpretation of the discovery rules. So Mr. Randazzo, the court would request that you prepare an order reflecting of the ruling of the court, and that it's granting your motion and quashing the subpoena without prejudice, and submit that either with the stipulation as to form or under the 7-day rule.
I'll submit it under the 7-day rule. Thank you, Judge.
Your Honor, may I ask a follow-up question?
Yes.
Looking at the complaint, we don't see a specific damage claim of impairment of earning capacity. I simply argued in my brief that it is recognized as an area of damages under the Michigan Standard Civil Jury Instructions. To the extent that plaintiff says that he is alleging an impairment of earning capacity and he attributes it to the incident, under that circumstance, if that's clarified by plaintiff, would that change the ruling you have issued today?
Well, I mean, I can see where a person's level of education or, their expressed interest in future careers and so forth might have some relevance to future damages, but I don't think having a school turn over a student's entire file, I mean, that's just going to be extremely broad and it's going to contain a lot of other information that, I put it this way, I think a discovery request seeking information related to future damages of his school files would have to be much more narrowly drafted for the court to find that it would be permissible.
Thank you, Your Honor.
Thank you, Judge.
All right.
Okay, thank you. That's all for today. Both parties are free to disconnect at this time.
Thank you, Judge. Have a good weekend.
Thank you. That concludes our docket for today. The